Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
Well, fellas, it's been quite a week in the world of non-competes. For those who may not be aware, the FTC last week proposed a rule that would forbid companies to subject workers to non-competes. They're using Section 5 of the FTC Act to supposedly support the rulemaking. And basically, under the proposal, non-competes would be designated an unfair method of competition, which the antitrust law prohibits. So I guess... Russell, how did we get here? And let's start with how did we get here, and then we'll go from there.
I feel like the Talking Heads song. How did we get here? Okay, so it all goes back to Jimmy John's in 2014. So, leading up to that, we had states starting to look at some of their non-compete laws. I know Georgia was doing that, Massachusetts was, Oregon, but it wasn't really a big deal. The Massachusetts one got a little bit of press attention because we were looking at a ban as a possible option. But really, at the federal level, nothing happened until 2014. And in 2014, the headlines were covered with the story about Jimmy John's, a sandwich shop where they were using non-competes for their sandwich workers. So the guys who, as you're walking down the line, they say, what kind of bread do you want? And you say, I'll take this. And they say, would you like lettuce and tomato on that? And you say, yes. Those guys had non-competes. And that caught the ire of the attorneys general in Illinois and in New York.
As well it should, right?
As well it should. No objection here, right? I mean, that's not an appropriate use for a non-compete. And I think, that was fairly obvious from the get-go. They've got reasons for why they were doing it. And we don't, I won't get into their reasons. But as a general matter, kind of looking at it from the outside, that did not seem like an appropriate use of non-competes. But because of that, a number of other companies started to get caught up in this web. And finally, in 2015, there was a bill that was filed in Congress to ban non-competes it was really for low-wage workers. There were actually two bills that were filed for that. And I think that was the year they also had a bill to ban non-competes for grocery store workers. So those were the three bills that were pending way back when in 2015. And then the Obama administration wound up looking at the issue, and this was very close to the end of President Obama's term. It was in the spring of 2016. And ultimately what they concluded was they weren't going to propose anything federally, but they wanted to have a call to action to the states to suggest to the states that they take some steps to rein in the abuses of non-competes. So not just the use of them, but the abuses of them. And specifically, the key pieces were the low-wage workers shouldn't have it. People who don't have access to information or can otherwise hurt the company shouldn't have non-competes. They should be given advance notice of them, that kind of thing. Then it was out there, and some states, were following up on that, but that didn't go anywhere at the federal side, nor did those federal bills. As we move forward in time, there had been a series of bills culminating in last year where there were 7 bills pending in Congress, ranging from a complete ban of non-competes, kind of like what we're going to talk about with the FTC right now. Complete ban, other than sale of business. You could not use a non-compete. And at the other end, there were some bills for prohibiting the use of non-competes for anyone who was not exempt under the Fair Labor Standards Act. And you could think generally that's hourly workers. And then There were actually some random other bills, including a bill that would prevent the enforcement of a non-compete for anybody who was terminated as a consequence of the refusal to comply with your COVID policies. So there were some things like, random things like that. But those were the key bills out there this past congressional session, and we'll see what happens coming in this new one. In the meantime, while Congress isn't really able to get anything passed on this, some Congress people pushed for the FTC to get involved and take a look at that. And that started way back. It was either like 2017 or 2018, but the real effort picked up in 2020 and 2021 when the FTC held some workshops. The first was a full-day workshop. The second was a 2-day workshop. The second one was during COVID, and so that was done remotely. The original one was in person. And the FTC looked at issues of its authority to regulate in this area, and if it does regulate, what that regulation should look like. They received a ton of input from external sources, so from lobbying groups to labor unions, which I've still never understood why labor unions care about this, to a group of lawyers, including some of us here, were involved in sending a letter to the FTC on this. And in the meantime, so that's the FTC side, and that progressed forward. And then in 2020, before President Biden was inaugurated, but after he was elected, he put out a statement about what his platform is, and part of it was that he wanted to ban the use of non-competes for, I forget his exact wording, but basically, ban the unfair use of non-competes, except as necessary to protect that narrow category of trade secrets. And it was unclear whether he meant like there was a narrow group of trade secrets that could be protected, or trade secrets in and of themselves were this narrow thing that could be protected. Either way, that's what he said beforehand. And then later in July of 2021, he issued an executive order saying that he was asking the FTC chair, that's Lina Khan, to work with the other commissioners to look into this issue and to ban any, again, unfair non-competes, as well as no poach agreements and any other agreements that might be unfair. And so they did take that up, and that's when everything continued with their efforts to come up with what they perceived to be an appropriate regulation. They looked at a bunch of research that has been amassing over the past 7 or 8 years, and they came up with the current rule, or the current proposed rule, which they filed on January 5th, so last week.
Thanks, Russell. That's that was a good history. John, before we get into talking about the proposed rule, any other thoughts or comments on how we got
here? No, I think Russell summarized it pretty well. The part about the legislation, I think, is noteworthy. I think that's something that could become more prominent when we talk about potential attacks on the rule, because there's an underlying current potentially here that the FTC is attempting to do through the back door what the legislative process has been unable to achieve, and that is one of the things that could become prominent ultimately in a litigation challenging. But yeah, I think the only thing I might add or reinforce that Russell talked about was just the number of bills that were being presented to Congress, largely on the Democratic side of the aisle. But Marco Rubio, I believe, had a bill as well. Russell, correct me if I'm mistaken, I believe it was directed towards primarily low-wage non-compete workers, if you will.
That's right. It was those who were non-exempt under the Fair Labor Standards Act.
Right. So the bulk of it has largely generated more from the Democratic side of the aisle. And as a result, obviously he's found some comfort, if you will, within the most recent administration's FTC. So not much else to add. I think Russell really knows this as well as anybody in the country, frankly, and I think he summarized it wonderfully.
Yeah, it is fascinating. For me, this dates back even further than 2014, as you alluded to, Russell. In Georgia, the law changed pretty drastically in 2011, but the process to get there started in 2008, 2009. And, I had the opportunity to go down and testify before the Georgia General Assembly when the legislation was being considered. And the legislation, ultimately, the intent of it was to make non-competes much easier to enforce by employers in particular. And, you guys have heard me say this 1,000 times. I got the reputation as being opposed, the lone voice out there opposed to the legislation. And that really wasn't a fair characterization. All I was doing was trying to get the General Assembly to think about some of these economic development issues, policy issues that I felt were just, hadn't even been thought about. And I think maybe what we can do is do a follow-up podcast, because I don't want to take too much time on this one. I think what we want to do in this one is focus on this rule and what we expect to happen and what it really means. But there are some, knotty underlying policy issues and how non-competes do or whether they do impact economic development as a whole, whether they impact the wages of workers and things of that nature that the FTC, purports to be concerned about in proposing this rule. I think Georgia really just the General Assembly just didn't seem to care about those issues, didn't seem to care one way or the other. They had an agenda and they followed it. But getting back to the issue here, Russell, what does the proposed rule seek to do? What do you foresee as the process as to whether it actually will be implemented?
So the short story is that the proposed rule seeks to ban all non-competes with the very narrow exception of, in the context of a sale of business, which I'll explain in a moment. But basically, every single non-compete, whether it's one that's about to be entered into or one that has already been entered into, all non-competes need to be eliminated. That would be if the proposed rule goes into place as currently written. It would require that employers also notify their employees that their non-competes are no longer enforceable, valid, in place. They're free of the non-compete. And that doesn't matter whether the non-compete was given to them in connection with the commencement of business, whether it was given to them in connection with a promotion, whether they received a bonus for the non-compete, whether they received stock or other equity for the non-compete. Doesn't matter. They're free of them. So that's the approach that the bill proposes on that. There is an exception. Well, actually, before I get to the exception, let me talk about the functional test. So that's with regard to regular non-competes, what we think of as the typical restriction that says you may not work for this amount of time in this geographic area doing basically what you were doing for us.
And so, Russell, that would apply to the non-compete that the CEO of Coca-Cola or the CEO of any major corporation might have.
Correct.
Incredible.
Doesn't matter what level they are, how much they've earned, how much they've been paid for it. None of it matters. It's gone. It doesn't end there because people have different views on non-competes and whether they should be enforceable or not. Obviously, California doesn't like them. Oklahoma, North Dakota doesn't like them. Even Nebraska's not very happy with them. But that's a legislative decision at the state level as a general matter. That's what historically it has always been. But this would go further. And this says that any other agreement that you have that might be, in the FTC's view, a de facto non-compete, because it cuts so broadly that it basically is a non-compete in the eyes of the FTC, that would also be invalidated. So take, for example, your non-disclosure agreement. If you have a non-disclosure agreement that says you can't use or disclose any of the company's confidential information, and it's just written in a way that it would arguably limit the person's ability to go work for a competitor because they would need to use that information, then that could be considered a non-compete. Of course, the problem with that is that if a person knows specific knowledge that they really can't be using at a new company, and this would mean that they couldn't go work for that new company in that particular role, that may actually be okay, right? The Uniform Trade Secrets Act or the Defend Trade Secrets Act, state or federal, would prohibit somebody from using that information in the new role. And if the consequence of that is that they really can't do their new job, that's their problem. They've got to make sure that they comply with their obligations to keep the information secret. For example, imagine you have a researcher who's been working on the development of a particular product. And now they go and they've tried all kinds of things. They know what works. They know what doesn't work. Now they go over to a new company, and the new company, and they don't have a non-compete. They just have a non-disclosure agreement. And they're going to do the exact same job for the new company. And they're going to be working on the same product, competitive version of it. And in the course of doing that work, they know all the things not to do. But they can't apply that knowledge to developing the product for the competitor. That saves the competitor a tremendous amount of time. So it's on them to not do that. It doesn't mean they can't go work for the company. They can go work for the company doing a variety of different things. They can work on different projects, but they cannot use the former employer's information in their new job. The FTC might take that and say, sorry, that's effectively a non-compete. Your non-disclosure is no longer good. You lose all the protections under that, which means you also are going to basically lose the protections under the Defend Trade Secrets Act or the Uniform Trade Secrets Act under state law. And, what are you supposed to do in that case? So that's one possible outcome with this so-called functional test or the de facto test in the statute.
Russell, what about like customer provision? So a customer non-solicit, I assume, would not be considered a non-compete, but what about a customer provision that prohibits not only solicitation, but acceptance of business from customers? Very often in Georgia, for example, those are often referred to as non-competes because they go beyond mere solicitation.
So I'll address that one, and then I'm going to come back to the non-solicit. So the no business agreement, no accept agreement, no service agreement, whatever the particular name, those types of agreements are definitely at risk. I would say if I were the FTC looking at it, I would say that probably fits within non-compete. It's a narrow non-compete, but it's a non-compete. And we're not going to allow it. But that remains to be seen. The other one, though, and it actually suffers from a similar potential risk as regular non-solicits, which is if the value of the person, say it's a salesperson, and the value of that person to the new employer is the book of business that they could bring with them from their old employer to the new employer. And without that, the new employer wouldn't hire them. Under the de facto test, this functional test, there is an argument that the individual, the employee could make to say that this non-solicit in my circumstances is acting as a de facto non-compete. It should be unenforced, and the FTC might agree with that. So even your the non-solicitation agreements are subject to invalidation under this test. The exact same thing would apply to a no service because it's basically the same thing but worse, right? It doesn't matter whether the employee solicit or not if they need to bring their book of business, and they even can't service the business when they get there. That's a real risk.
Hey, John, you were going to jump in there. Sorry about that.
No, don't even worry about it. I was just going to chime in kind of on the points that Russell's reinforcing now. And particularly on the non-disclosure side of thing and this tension between trade secret protection on the one side and employee mobility on the other. Obviously, that's an issue that we've worked through in multiple contexts before, both in litigation with the AIPLA, Sedona, et cetera. But I was disappointed that the FTC acknowledged the avenue of trade secret protection as one of the reasons for not having a need for non-competes. And in the CFR that accompanies it, spent about 5 to 10 pages talking about all these great protections that are available to employers under the Defend Trade Secrets Act, under the Uniform Trade Secret Act, criminal penalties under the Economic Espionage Act. But then it puts those very protections at risk by this de facto non-compete functional test, if you will, and doesn't really provide any kind of detail or clarity on how an employer can straddle those potentially conflicting tensions, those policy considerations, if you will. So I do think it's really problematic on the trade secret side, because as Russell noted, you've got a situation where someone who's involved in a core R&D project could make the argument that they're effectively suffering from a de facto non-compete if all they're bound by is a non-disclosure agreement and are prohibited from working for a competitor. So having some clarity there would be very useful for employers that have these on NDAs.
Yeah, all good issues. So, what if this rule were to go into effect? What are the potential infirmities? What are the areas where there could be challenges? Russell, you want to start with that?
Well, let me, before we get there, just the exceptions.
Right.
Because there is one exception, and it's somewhat illusory. The exception is that in the context of the sale of a business, so if an employee is selling an ownership interest in the business or the business is being sold, and the employee has 25% or more of an ownership in the company that's being sold, or it is a 25% interest in the company, and that's being sold. In that context, a non-compete can be enforced. And so at first blush, you look and think, well, that makes sense. Actually, right. Sale of business. Every state recognizes an exception. Even the states that don't enforce non-competes recognize an exception for non-competes in the context of a sale of business. The problem is that what this means is, at most, in any company, 4 people can be restricted, because 25% means if somebody has more than 25%, somebody else has less, if there are 4 or more people, right? So the maximum number of people that could be bound by a non-compete, even if you've got 15 key people at the company who really need to be bound by non-competes in order to ensure that the value of the company is being transferred, those people, it won't work. You can only get 4, and it's only the 4 that have at least 25%. Second problem is it completely ignores the value of the company. So if the company sells, let's say it's $1 million, and or let's say it's $100,000, right? Small company, $100,000 net out of the sale, and that gets distributed. That's going to be $25,000, and you have 4 shareholders each owning 25%. That's $25,000 apiece, and you can bind them to a non-compete, right? So they get $25,000 bound to a non-compete. In contrast, if you have a company that has 5 shareholders, so everyone owns 20%, equal shareholders, everyone owns 20%, and it sells for $100 million. So everyone would get $20 million for this. None of them can have a non-compete. That's a highlight of a problem with the way this is laid out. So they really need to, if they're going to do the sale of business, they really need to take a different approach on that. And what they have right now really, I think, is somewhat illusory. Just one other thing in terms of the expected time frame. Right now, we're waiting for the proposed rule to get published in the Federal Register. When it gets published in the Federal Register, that will start a 60-day window for anybody to submit public comments. And I know the FTC wants public comments. If you read through their notice, every section either says in the middle of the section and at the end, or just at the end, please comment on this. We want comments on this. So they are looking for comments. And if they receive comments that they find to be persuasive, we can hope and expect that maybe they will make some changes to this. You've got a 60-day window for that to happen once this gets published. We'll see when that gets published. And then once the final rule issues, it'll be another 180 days before you have to comply with it. But, what I would recommend is if somebody is aware that the final rule, once passed or once issued, is something that they will need to comply with and they're not in compliance with, I would not wait for the 180 days to pass. I would actually take steps immediately to make sure that I comply with that, so that there's no problem ensuring that you've done everything in good faith to get full compliance by the time that the expiration comes around.
Just real quick on that exception, it's interesting because our statute in Georgia has something similar, where if someone does not own 25% or more in a sale of a business, there's other ways to bind them to a non-compete, but that does create problems. So to your point, it's arbitrary and it just makes no sense in that context.
Agreed.
So let's talk about, we've got the major question doctrine from the West Virginia versus EPA case. As I know that our friend Eric Weibust has a great paper and blog on that. But there's other potential challenges or infirmities with the rule. Do you want to talk about those?
I'm happy to hop in on that one. And I looked a little bit at Eric's article in advance of our podcast and did a little bit of research on my own. And you all probably remember that decision from last year. The 6-3 decision broke down largely on ideological grounds. And the decision set aside a regulation that the EPA had been attempting to promulgate. I think it even withdrew it at some point. So there was a mootness argument that occurred, but essentially they were attempting to regulate greenhouse gas emissions. And the challenge from one of the states was that they lacked a clear congressional grant of authority for it. And I think that's going to be an issue that's front and center here, is whether the FTC has a clear statutory grant to regulate these types of agreements. I know that Commissioner Wilson, she's the lone Republican commissioner at this point, Russell.
Yes.
And in her dissent, she points out a Seventh Circuit opinion, but I looked at briefly earlier today, that rejected, at least in that case in 1963. Admittedly, there hasn't been a whole lot of activity by the FTC in terms of managing restrictive covenants or non-competes. But in that particular case, the Seventh Circuit had rejected it, Snap-on Tools versus the FTC. So there really has not been historically a lot of activity by the FTC in this area. That doesn't appear, at least so far as I've heard, that there's a clear congressional grant. I suspect that what we're going to hear from the FTC is that the empirical evidence that has suddenly emerged over the course of the last 10 or 15 years justifies their involvement, and that this wasn't available to them before, and that'll be the justification now for the exercise of jurisdiction here. But I think they will be swimming upstream, and some of the commentary I've seen that I respect seems to support that they will struggle to find the clear statutory grant of language that the Supreme Court, at least a majority of the Supreme Court, seems to be requiring now. I think another issue that's really interesting, and the potential for mischief should an employer or someone who's opposing the rule wish to bring litigation, is the issue of the supremacy clause. Because as we are all aware, non-competes have traditionally been creatures of state law. They've not been the subject of any successful federal legislation, have largely been left to the states. And I was underwhelmed, frankly, with the invocation of the supremacy clause and the preemption of state law that was mentioned in passing in, again, the CFR that's accompanying this. So I think that's another area for attack. I saw something, and Russell, I'd be interested in hearing your thoughts, whether you saw the same thing. I saw an article where someone was talking about another constitutional attack on private contracts. I have to confess that's not something that I've been involved with before, but I don't know if that's something that you've heard about or read about in the ramp up to this podcast.
So there is something about, right, can Congress is really where it comes out normally, right? Invalidate existing contracts between private parties. I have not researched that. We looked at that very briefly back when we were working on the Massachusetts legislation, and ultimately concluded that we didn't need to worry about it because it wasn't retroactive. But whether there would be a problem if it had been retroactive was still an open question that wasn't resolved. So I don't know the answer offhand, but certainly that's going to come up if there's a challenge.
What are your thoughts? Go ahead, Ben.
No, sorry, John. I don't know if you were still going to talk about that or shift gears to the empirical data question.
You read my mind. That's exactly what I was going to ask.
So what's real interesting to me about that, and I think it was Evan Starr who I had the conversation with about this, which is, there have been a few states. So Michigan, for example, non-competes were not enforceable until the mid-'80s at some time. And then through a quirk in the law there, they became enforceable. And people have tried to look at the before and after to see the impact. I always thought that Georgia, with our law changing in 2011, would be a perfect laboratory to figure it out. But when you talk to folks like Evan Starr and others, I think that there is this question about you just can't control for all of the variables. So, for example, in Georgia, our law passed and went into effect in 2011. And that was, as the biggest recession in several generations was ending, and the economy here and everywhere took off. So it'd be very difficult to control for other factors to see, for example, what the economic impact was of that statute. But John, do you want to talk about sort of, what is there really empirical data, and what kind of data is required in order for a rule like this to be enforced?
To quote a wise man, that one's outside my pay grade. I may kick that one to Russell at the end of the day, because I have to confess I haven't rolled up my sleeves and really looked at it. I mean, I was struck. Certainly, there references to a lot of the studies and articles that we've looked at over the years, or talked about over the years. But I was struck by the amount of anecdotal citation. When you read through the CFR at the beginning, there's sort of a litany of situations involving a steel executive in Ohio, or a stylist in Minneapolis, or whatever it might be. But in terms of the empirical stuff, I'm going to punt to Russell on that, because Russell, I feel you've got a better handle on that than I do.
So the majority do say that they do cite to various or talk about support that they have for that. And there absolutely are studies that provide support for much of what they say. But even as the majority acknowledges, there are studies that are on the other side of this. And when you look at Commissioner Wilson's dissent, you see her objection, you see that she references a number of things about the studies, and it's points that we've made before in correspondence with them, which is the studies. First of all, the studies that the FTC itself, the majority, rely on are nascent. They are not necessarily showing causation as opposed to correlation. They have inherent other problems with them. I'm not an economist. I can't get into all of them, but I know there are certainly additional problems, and they are not nuanced. And so when you then start looking at the evidence or the research on the other side, you see that there are benefits to non-competes that are not looked at by the studies that the majority relies on. So, for example, some studies have shown, and again, even these studies suffer from the same infirmity of causation versus correlation. But if you're going to look at studies on one side, you should look at them on both sides. And on the benefits of non-competes, they've shown that there are increased wages and increased accountability for CEOs and other executives when non-competes are in place. That when non-competes are in place, there's increased training and job satisfaction if the employee has been given advance notice of the non-compete. That when non-competes are not used or not enforced, then there are higher costs to consumers, at least in the mutual fund industry. And there are, when non-competes are not used, there are higher rates of employee misconduct by financial advisors and higher fees charged to consumers by financial advisors. And then when you look at the states that are willing to enforce non-competes, you have fewer startups as compared to states that are less willing or unwilling to enforce non-compete. However, the startups that you see in the enforcing states tend to be better quality startups. And that's also ignored, right? So all of these benefits of non-competes aren't taken into account in any material way in the majority's opinion. And I think that's important because we really only are looking primarily at one side of the equation if we're just looking at the harms of non-competes and not looking at the benefits of them. And by removing them, what benefits are going to go away? And I'll give you another example, which really isn't the subject of any studies, but you got to step back and look at the history here. And to your point before, Ben, your question before, how did we get here? Well, in 2014, Create.org, which no longer exists, but did a study along with Price Waterhouse that looked at what are the estimated costs to the American economy of misappropriation of trade secrets. And that was, I believe they came out, it was 1 to 3% of the gross domestic product, I believe was the number, which wound up translating roughly to somewhere, up to half $500 billion of loss, right? Like $480 billion, I think, in a year. And that was a big motivator. The theft of trade secrets was the motivator, and the significance to the economy was the motivator for Congress to virtually unanimously pass the DTSA. So you've got that going on, and non-competes are a critical tool for protecting trade secrets from departing employees in particular. And we also know that departing employees are the biggest risk to your trade secrets. So the tool to protect against that is the prophylactic tool of a non-compete. Don't let them go work for a company where they put your trade secrets at risk. It's just that simple. We don't have to worry about whether they're doing it and we don't know about it. So when you consider the effects of that, which really aren't taken into account in the FTC's notice of proposed rulemaking, the effects of that have to be potentially enormous, right? You're going from what is estimated to be several $100 billion at a minimum, right, of misappropriated trade secrets, and you're opening up the door for more, or at least increasing the risk. We know there will be more. We don't know how much more, but that's a real risk, and I don't think that's taken into account.
Yeah, all good thoughts, Russell. I know that one of the ones that Evan Starr, I think it was the one who had done some research and not surprisingly came to a conclusion that non-competes do favor larger, more established companies, and to your point, do reduce the number of startups. And I think that's another one of those where you have to make policy decisions, right? If the Georgia General Assembly had been thinking about it, and I think on some level on that issue they were, which was they were looking to protect the large established companies that employed a lot of people here, and were less concerned about fostering a startup environment like might exist in California. So I do think there's policy issues too that have to be considered. But to your point, there's so much on both sides that I don't know how the FTC could conclude that banning of all non-competes is ultimately the best thing for the economy and or for workers. Well, what about the comment period? I know we touched on it briefly, but what's going to happen next, and then what should employers do in the interim?
So the comment period, right, 60 days to comment once it gets published in the Federal Register. So that's going to happen very soon. And in the past, in connection with the two workshops and in connection with President Biden's executive order, I, along with many others, had submitted a letter in each instance. And we had about, I think, John, what do we have? About almost 60 lawyers in the last one?
60?
Yeah, I think it was about 60 in the last
one.
one.
Because it did much. It continued to grow. You're right.
Yeah, each one got, we had more people signing on to it. And I expect, we'll be doing another letter, and I expect we'll have more people signing on to that. And so we are going to submit a letter that identifies a lot of these issues that we're talking about and talks about what in our experience, based on legislation that we've seen at the state level and based on the practical impacts of non-competes that are enforceable versus non-competes that are not enforceable and how that works, and also the practical impacts of this functional test, the de facto test. I expect we'll be doing a letter that addresses all of those issues and brings to the FTC's attention the concerns that we have based on what the rule is. Not advocating, but really just identifying to them, these are the issues, and you do with it what you want. You're the decision makers here. But I think we're not the only ones. The last go around on this, there were 328 comments, if I recall, from different groups and from individuals. They ranged. And I think on this one, we'll have, based on what I've seen so far, we're going to have at least 60 signatories to this letter, and welcome anybody else who wants to look at it before we finalize it and make any comments you want, and join if you want, or not, or take a different position. But we're making it available for anybody just so that it's easier for people to have their voice heard if they agree with the approach that we're going to recommend.
So what should we be telling our clients in the meantime?
That is the million-dollar question. So I think we have to view it in the context not just of the rule, the proposed rule, but also in the context of what's already happened. And remember, there were 3 enforcement actions that the FTC filed the day before releasing this proposed rule. And the 3 enforcement actions were against 2 types of organizations, as well as some individuals. But the first was against a company that a company that provides security guard services, and that company was using, or those companies were using non-competes for security guards. So you could see that's an easy one for the FTC to get motivated about. Lower wage workers being bound by non-competes, and really, what's the legitimate interest being protected there would be the question, right? And so they entered into a consent order there. The other were companies in the glass making business, for glasses, like for bottles and that kind of thing, and which the FTC says is a very small market and very hard to get into, and therefore creates this potential lack of fluidity for employees, right? They have no place to go if they're subject to non-compete. So the FTC entered into consent orders with the companies in both of those cases. You look at that, and then you look at some of the cases that the FTC identified in its proposed notice of rulemaking, and they give you a clear signal about what they think is going to be inappropriate. And I think the takeaways from that is stop using non-competes for low-wage workers, right? If you're not already doing that, there are 11 states plus DC already that you have to comply with if you're in those states. For everybody else at this point, I think the FTC is going to do something, and I think it's going to, at minimum, ban the use of non-competes for low-wage workers. And I could see that they come after companies using non-competes for low-wage workers even before the rule gets issued, because they've already started doing stuff like that. And it also supports their proposed rulemaking. So I would 100% say stop using them for low-wage workers. At the other end, I'd say, look, if you need them for your C-suite and the senior executives that you care about, do it, because I don't think it's going to create any real problems. I think the FTC may tell you ultimately that you need to get rid of them, and then we'll have to figure out what to do once we see what the rule is and what the challenges are. But that, to me, isn't the kind of thing that really gets the FTC or anyone else particularly upset, right? These are high-wage workers. Then you've got that whole swath in the middle, and I think that's a judgment call at that point. And I think that you got to look at the particular companies and decide at what level are you comfortable saying we're going to use non-competes for everything above this and we're going to stop using them for everything below. That's on the non-compete side. The other agreements, you better take a real close look at all your other agreements. Your non-disclosure agreements, a number of us, I think we've all been part of this discussion. We've talked about an exception in the non-disclosure agreements that we write to exclude from the protections any information, not only that's public or has been made public through no fault of the individual, but also any information that may qualify as general skill or knowledge of the employee and wouldn't be protectable under the law. That now seems to me, in light of the FTC's proposed rule, to be a very wise thing to include in your non-competes, include that kind of an exception. I think you got to really start looking at them and making sure that they are narrowly tailored. Same for non-solicitation agreements, same for no recruit agreements, same for no service agreements, if they may wind up being permitted at all.
Those are all great points, Russell. I think, I guess a question that I have, and I don't know if we have the answer yet, which is there could be this chaotic period, right, where the rule goes into effect. Certainly there will be legal challenges, but, could we expect, for example, a federal judge to enjoin the rule from being enforced while the litigation works its way through? Or will we be in this sort of unknown situation where you have this rule, it's being challenged, but it remains on the books and something that has to be considered?
I think that's absolutely a potential outcome. I think it also will depend on what jurisdiction. If you're in California, nobody's enjoining that, enjoining the rule. If you're in Florida, I think the judge will just be waiting, for someone to come down so they can enjoin that.
You're right. I mean, there's going to be a really interesting forum shopping battle that probably takes place here, and I would expect that a gaggle of employers or industry associations will try and find the most hospitable federal court and try to deliver that knockout blow in the short term.
John is so much more diplomatic.
Yeah, exactly. But you're right, though. I think you'll see someone try to find a favorable location and try and get what amounts to a nationwide injunction. Whether they can get it will be another matter, but it'll be interesting to watch. Just to chime in real quick, I know we've gone a while here, but I just want to echo what Russell said. I think what Russell provided spot on. I think that advice makes eminent sense. And it's funny because it's largely what we've been advocating even before this proposed rule came down. Keep your non-competes narrow as possible. Use them sparingly. Have the carve-outs in your non-disclosure agreement for public information or general skill and knowledge. All of these things are hopefully advice that many people have been taking, and I know we're not alone in offering that. I think when I look at blog posts or client alerts from others in our space, they very consistently offer that same advice. So hopefully people have been following it, but it's there's obviously enough of an anecdotal record, maybe more than an anecdotal record, of people abusing non-competes that unfortunately have triggered the interest in action of the FTC.
Well, final question. Any predictions on whether this rule will be implemented, and if so, when?
My prediction, I have two. One is it ultimately winds up being a ban on the use of non-competes for low-wage workers. How you define low-wage workers is a question, but I think that's what it'll be. That's my one prediction. My other prediction is it's a complete ban. It remains the way it is. I don't see anything in between.
You're really hedging your bets there, Russ.
I definitely like to cover my bases. It's become, a bit of a political issue, right? I mean, you could see you've got Democrats on the one side and the Republicans on the other. I know that former Commissioner Noah Phillips, had taken the same position that Commissioner Wilson takes. And so it really is a party divide. And I think that Chair Khan is a strong proponent of a full ban. So that's why I want to hedge the bets. However, they did ask for a lot of comments in the notice of proposed rulemaking. If you believe that that's really going to be taken, asked in good faith, then they'll take the input, which I do. I think that I could absolutely see them coming out at the end of the day with a real reasoned, narrow restriction. Now, I'm not going to say that they have authority for that. That's not my real area, right? My area is the substance of it, not the procedural piece of it. But whether they have authority or not, that's what I think they'll wind up coming out with.
I think they're going to offer a full ban. And I feel that the political momentum is such, and the sort of the polarization that Russell described is so pronounced at this point. It's tough for me to see the FTC walking back from that, but I could be wrong. I'll add a second prediction. I think that whether that ban's successful or not, and I think there are enough legal hurdles about whether it is ultimately successful, is a real open question. I think that it is going to cause people to, in the interim, and out of an avoidance of controversy, if you will, or the path of least resistance, to stop using them or to find other alternative measures, whether it's a combination of a narrow non-solicit and a reasonable non-disclosure agreement. And in some ways, that may ultimately signal really the final decline, if you will, of the non-compete in an awful lot of places in the country.
I think that's part of their goal in reality, right? Whatever they wind up doing, they've certainly sent a message already.
Yeah.
And some companies, I think, will say, enough, we're not going to take the risk. But I do know also lots of companies that will say, no, we think we're right about this. We don't think they have authority. We think that we need these to protect our business, and we're not going to just roll over until a court tells us that we're not allowed to do this. That the new rule is enforceable and we're not allowed to do this.
Yeah, I think you're right. And John, I think if I asked Russell who's going to win tonight's national championship game, he'd say, well, University of Georgia, unless TCU plays really well, then they might win. Based on his prediction.
Is that a problem?
You had to rub that in, didn't you, Ben?
Sorry, John. I couldn't.
All right,
couldn't
well,
help
that's
it.
okay. Russell, you feel free to jump on and remind him of the the New England Atlanta Super Bowl matchup.
And Russell's sitting there wondering what the heck we're talking about.
Tom, who?
Well, fellas, I think that was a really good discussion. Obviously this is going to be real interesting to watch it play out. We will absolutely do our best to keep our listeners informed as developments occur. And until then, look forward to our next podcast.
Likewise. Thank you.
Thanks, everybody.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.